Grellner was in on the show yesterday and was talking about this new criminal code. St. Louis County prosecuting attorney wants to talk about it. Bob McCulloch, welcome back to the Big 550 KTRS.
Good morning, McGraw. Thanks for having me in.
You got it. First, explain what they did with this criminal code. They rewrote the whole thing?
Well, a little background on this. Prior to or in the mid-'70s, the law was all over the books, literally all over the books. And so a legislative committee got together and they redrafted a lot of the criminal laws, got rid of some of the arcane language that was in there. Assault with intent to ravish with malice became rape, which is what it is. And so, but they put everything in one section in the statutes, which obviously is the definition of a code. And so I worked under both of those systems for about a year under the old one and then the new one, and it was night and day because you could go to one spot, you knew what it was very clear. Over the years since that time, the legislature has passed a variety of laws, and again, they're all over the books. There's some, the drug laws are in some regulatory sections, other laws are outside of the code, and so the prosecutor started about 6 years ago bringing everything back in. We worked on that for a couple of years, then got with the public defenders and the defense bar, worked with them, eventually the Bar Association, the courts, legislators, and then about 3 years ago began seriously drafting, bringing things back in. Whatever was a crime before is still a crime. It doesn't change on this, but we put it back into code form. And so if it's a crime today, it's a crime tomorrow, and it's a crime when this code takes effect. The idea with the code on the delay in implementation, just as it was in the late 70s, is that the courts have an opportunity now. They have to draft the charge codes. They'll have to draft jury instructions and take care of all that. And so that's part of the implementation, which also gives them the opportunity. And the courts have been involved looking at this too. And they will look at it and say, all right, fine, this isn't terribly clear right here. So let's, we need to clarify that. So there's also the opportunity for that. So what I wanted to respond specifically about with Detective Grellner's talk yesterday is that that was the process that it's gone through. This code has had more than 24 public hearings over the last 2 years across the state in the legislature. This is how legislation is supposed to be drafted. It was vetted by everybody with a stake in this, from the victim advocacy groups to law enforcement, prosecutors, defenders, legislators, the courts. Everyone has been involved in this. And there hasn't been, and believe me, there's no perfect piece of legislation that has ever come out of Jefferson City or ever will come out of Jefferson City. And so, like most legislation, this is a compilation, and we put together something that we think is a good code and everyone can live with. As yet, there has not been a real problem pointed out. Detective Grellner yesterday, talking about the essentially decriminalizing the possession of certain amounts of ephedrine. That language isn't gone. It's identical to what it was. It simply moved from the drug regulatory provisions into the criminal code, just picked up and moved over. And it's those sorts of things that come in. An example of how it should work, Detective Grellner, unfortunately, sent his concerns to the media, not to the legislature. All he had to do was pick up the phone and ask somebody, and it would have been clarified. We had a prosecutor the other day who works on DWI cases an awful lot, who had a concern that the habitual habitual offender on DWIs disappeared, and was concerned about that, as he should be. But he called the association and said, no, it was moved over to the dangerous felony category, which now means that an habitual drunk has to serve 85% of the sentence. So everything is still there, and it's just a question of finding it in the code. But it's in a code. You got one place to go for all of this now.
The two things Jason Grellner brought up yesterday. One, he said that law enforcement didn't have a seat at the table. You disagree with that?
I disagree with that. Law enforcement was, the people at the table, the people doing the actual drafting, are those who know how to draft statutes or know how to draft laws. And those aren't legislators even. Those are the people in the Senate drafting and the House drafting. They're people who do that for a living. But all of that is vetted by various organizations, including law enforcement. We met with the police chiefs, with the even the Narcotics Association, the sex crimes, law enforcement who are involved in sex crimes cases, the prosecutors who do that, defense attorneys. Everybody was around for that. Now, I can't say Detective Grellner himself was contacted,
Sure.
but certainly law enforcement from one end of the state to the other participated in this, and certainly, I mean, we wouldn't be thinking about doing criminal laws without all the stakeholders and victim advocates. Anyone you can think of who has a stake in the criminal justice system is involved in this.
Bob McCulloch, no one calls you soft on crime. When it's all said and done, so you are in favor of this new criminal code?
I'm absolutely in favor of it, and in fact, I'm getting ready to head to Jefferson City right now to certainly urge the governor not to veto this thing. There's absolutely no reason, no basis for vetoing this bill, but also to drum up support to override any veto that may come out of it.
Gotcha.
I can't imagine why this would not be signed. This is a piece of legislation that is long overdue, and really is very necessary. And it's well crafted and put together, and we still got a lot of work to do with getting the charge codes together. And again, it doesn't take effect until January of 2017.
While I still have you, Bob McCulloch,
Sure.
did the governor have any input? Did the governor have a seat at the table in this legislation?
We asked the governor's office if they wanted to participate, and that was at least 2 years ago, and they decided not to get involved directly in the participation or in drafting that. However, we kept the governor's office well advised as to where the code stood, where the provisions were, where it was going. I know I met with his legislative aide. Now, the governor's a very busy guy, of course, but we met with his legislative director. I'm going to say once a week or every 2 weeks, certainly all through last legislative session. And then the legislators have met with his staff, too, to kind of keep them apprised of this. That was really the other part, and I'm glad you brought that up, because Detective Grellner indicated 15 days isn't enough time to review this. I agree with that. But the 15 days, like any legislation, is the governor has 15 days to sign it, veto it, or do nothing and let it become law. This has been in the process. None of this legislation comes as a surprise to anyone, not to the governor's office. They've had ample opportunity to review everything in there, as has anyone else who's been interested in it.
Yeah.
Detective Grellner made the mistake that a lot of people make, is that you read a portion of a section and not the code, not the pertinent sections are on there. It's a common mistake that people make when they look at it and say, "Wait a minute, this is gone." They don't look to see if it's somewhere else or ask the question.
Yeah. Bob McCulloch, while I still have you, what are your thoughts on Daniel Hughes and his acquittal yesterday of molesting that child at the Ritz-Carlton?
Yeah, it's I haven't had a chance to sit and discuss that with my prosecutor yet. We'll do all that, but it's obviously very disappointing. We ask juries to make these decisions, and we give them all the information and the evidence. So even though I disagree with jury verdicts sometimes, I don't quarrel with them. We ask them to make the decision, and they made it. So we'll accept that decision and go from there. But as I said, it's very disappointing, and I'm like most people. I don't know how you force your way into a locked hotel room and crawl in bed with a complete stranger by everyone's account, and somehow that's not a crime, particularly when the stranger is a 9-year-old. But that was the jury's decision to make, and unfortunately, they determined it was not guilty.
Is there anything your office could have done extra to sort of secure the?
Yeah, that's kind of what part of the review process. We'll go back and I'll meet with my prosecutor on it. And by the way, is as good as they get. Kathy Elizadeh, the chief of my sex crimes unit, and there isn't anyone better out there. But we will look at everything and see, well, could we have done this differently, or should we have done that, as we do in pretty much in every case that goes on, as any good lawyer would do.
Yeah. People who heard about it yesterday afternoon were shocked. Is Is it safe to say that you, as a county prosecuting attorney, you were shocked by the jury's verdict?
Shocked might be too strong, but certainly I was very surprised by that. I could understand, I think part of it, and I said we'll explore it, but I think the sympathy factor comes in. This guy got blind drunk and did something stupid, but I also have, just that nagging thought that if he got blind drunk and got in the car and crossed the center line and killed this little girl in a car accident, somehow I think that understanding wouldn't be there. And that's why it's a difficult verdict to take. But as I said, it's their decision.
Yeah, St. Louis County Prosecuting Attorney Robert McCulloch. Bob, you're always welcome on the show. Thanks for stopping by.
Great, I'll be back.
You got it. 7:31 here, Big 550 KT.